Welcome back to the third part of the session on duty of care. Here we're going to focus on the area of psychiatric harm, which is also known as nervous shock. Now, the term nervous shock is used in a shorthand fashion to signify a medically recognized psychiatric illness or disorder. A claim for nervous shock is a claim for damages for psychiatric injury where the claimant has not actually suffered any physical injury whatsoever. So the kinds of persons who can make a claim include persons who were at risk of physical injury but only suffered psychiatric injury. Other persons who can claim include persons who were never at risk of physical injury but sustained psychiatric injury as a result of witnessing injury to somebody else, or actually believed that somebody else was at risk of injury. And the class of possible claimants also include rescuers and those who are led to believe that they were responsible for an accident which resulted or might have resulted in injury to somebody else. Again, a successful action is only available for a recognized psychiatric illness. So it is not recoverable for grief or distress or sorrow. So if you get an exam problem, for example, which says that the person has suffered psychiatric damage, please take it as read. It is a gift from the examiner and they do not come often. Psychiatric damage encompasses all relevant forms of mental illness, neurosis, and personality change. So it has to be distinguished from emotional distress or grief, as I mentioned earlier, which normal individuals may suffer when someone else is injured or killed. The problem is, the distinction may sometimes be very difficult to draw. There can be no claim for emotional distress or anguish or grief unless that then leads to a positive psychiatric illness. Now, if we start at the background to this area of law, an early case of just mere psychiatric injury was Victorian Railways Commissioners and Coultas. This is an 1888 case where the defendant's servant permitted the plaintiff to drive across a level crossing when a train was approaching. There was no actual impact and so there was no physical injury, but it was what we would call a near miss. And that resulted in the plaintiff suffering nervous shock and had a subsequent miscarriage. Now, her action for damages failed because the injury was held by the court to be too remote. Now, we can see a change of attitude though, and in Dulu and White in 1901, the plaintiff who was pregnant was a barmaid. She suffered shock followed by illness and the premature birth of her child when a cart and its runaway horses crashed through into the pub where she was working. Again, there was no impact causing physical injury, but she was in fear of her own safety, and it was on this basis that her claim succeeded. Now, in the case, Justice Kennedy explained that recovery of damages for nervous shock should be limited to such cases. In the case of Boyle and Young in 1943, the plaintiff heard the noise of an accident and later she saw blood on the road. She was not a primary victim, something we will discuss later. Neither did she have any relationship with the accident victim, and maybe it was therefore not surprising that her action for damages for nervous shock failed. Such injury was held not to be reasonably foreseeable, but the case can also be explained on policy grounds. She was no more than a mere bystander to whom no duty of care was owed, but her claim was not dismissed specifically on that ground. Now, in McLaughlin and O'Brien, big case that you really need to know about, this is a 1983 case, and the plaintiff was not a participant in or even a witness of the accident in which her daughter was killed and other members of her family were injured. However, she did see the immediate aftermath and suffered nervous shock. Now, the House of Lords held unanimously that her nervous shock was foreseeable and her claim for damages in negligence was actually successful. Now, it was the House of Lords in 1992, in the case of Alcock and Chief Constable of South Yorkshire, that made the legal position clear. And I would urge you to look at Alcock, because Alcock contains an extraordinary amount of information that you will need. Now, this was a case arising out of the Hillsborough disaster, and the case itself involved secondary victims, and their lordships confirmed what were now well-established requirements in such cases. That is, the psychiatric injury must have been induced by shock, and that the event must have been likely to result in nervous shock to a person of normal fortitude. They then made it clear that reasonable foreseeability of nervous shock was not enough to give rise to a duty of care. Now, that is important. They said there had to be a degree of proximity in terms of the closeness of the plaintiff's relationship with the primary victim, the closeness of the plaintiff to the accident in time and space, and the means by which the shock was suffered. With regard to the first point, parents and spouses of the primary victim are usually presumed to satisfy that requirement of the closeness. Other relationships, though, will have to prove it. This, of course, conjures up the rather distasteful image of a sister, for example, having to provide evidence of her love for her sibling, albeit that she possibly witnessed her sibling's harm. Whilst the decision answers some questions, however, particularly that foreseeability alone is not sufficient to establish a duty of care in cases of secondary victims, it raises others in that it does not, for example, rule out completely certain possible plaintiffs. Now, we come to the case of Page and Smith, an important case when one considers primary victims. And this is where the House of Lords was required to consider nervous shock. The facts are these. Mr. Page was involved in a road accident in 1987 when Mr. Smith drove his car across Mr. Page's path. Now, Mr. Page suffered no physical injury, and neither did Mr. Smith. But Mr. Page had suffered for the previous 20 years from a condition known as myalgic encephalomyelitis, or ME for short, which was in remission at the time of the accident. However, about 3 hours after the accident, he started feeling exhausted, and the exhaustion continued. He brought this action for damages for personal injury caused by Mr. Smith's negligence, claiming that it had brought about a recurrence of his ME. Mr. Smith admitted liability for the accident. That was not in dispute. But Mr. Smith said that he was not liable for the damages that were being claimed. The trial judge, of course, found for Mr. Page, but the Court of Appeal unanimously allowed Mr. Smith's appeal on the grounds that Mr. Page's injury by nervous shock was not reasonably foreseeable. Now, of course, Mr. Page appealed to the House of Lords. And in giving the leading judgment and allowing Mr. Page's appeal, Lord Lloyd defined primary victim by reference to the foreseeable risk of physical injury. And he considered that a primary victim is someone within the zone of foreseeable physical harm should the defendant fail to take reasonable care. Now, there are 3 cases worthy of mention and which I would urge you to go to the source materials in order to have a better review of them. So go to the cases and the textbooks to review these. The cases, of course, are McFarlane and E.E. Caledonia Limited, which offers a discussion of an extraordinary event in circumstances where you're looking at a bystander. The next case is Frost and Chief Constable of South Yorkshire for the police officer's claim and a discussion as it relates to rescuers. And lastly, the case of Dooley and Camillade for the responsibility of employers for psychiatric injury caused to employees. Overall, in the context of psychiatric harm and in this area, we see that there are certain key principles that can be summarized in 7 main points. And they are these. The first is that in every case, the claimant must have suffered a recognized psychiatric disorder as opposed to mere grief, anger, or anxiety. So what I need you to do is to see what the examiner tells you in a problem question about the harm suffered. If the examiner says that the claimant suffered psychiatric damage, or he said that the claimant suffered post-traumatic stress disorder, then as mentioned earlier, these will amount to a recognized psychiatric injury. The second point, of course, is that a bystander cannot recover for nervous shock. And if I may pause there a minute, one of the points raised in Alcock was that if it was that you had witnessed something so extraordinary, then it may be that you could recover. However, in the case of E.E. Caledonia, the door was firmly shut because that was a case about the Piper Alpha disaster, and the fact is that this gentleman witnessed his friends being blown up, but unfortunately, because he was a bystander, he couldn't recover. The third point then is that where a defendant is negligent in his act or omission, and he exposes the claimant to the risk of physical injury, if the act or omission causes the defendant psychiatric injury, even if there is no physical injury, then the claimant can recover. And this is even if the psychiatric injury itself was not reasonably foreseeable. This, of course, covers your primary victim. The fourth key principle is in the area of rescuers. And it is that a rescuer who objectively exposes himself to danger can recover whether the psychiatric injury is caused by fear for his own safety or the horror at what he has seen. The case for this authority, of course, is Frost and Chief Constable of South Yorkshire. And I would want you to bear in mind that Justice Cardozo had famously remarked that rescue invites danger, and it makes sense, therefore, for a rescuer to be able to recover. The fifth main principle is that a rescuer who reasonably believed that he was exposing himself to danger can recover whether the psychiatric injury is caused by fear for his own safety or horror at what he sees. Again, Frost stands for that proposition. So they are considered primary victims, but please ensure you look at the decision in Frost as well as in White and Chief Constable of South Yorkshire. As in White, the police officers were unable to recover because it is thought you're a police officer. You should be not immune to such things, but it is part of your job, more or less. The sixth main point, of course, is that where the negligent act or omission of the defendant has put the claimant in the position of being or thinking that he's about to be or has been the involuntary cause of somebody else's death or injury, and the psychiatric injury stems from the shock to the claimant of that supposed fact, then that claimant can recover. And this, of course, comes from Lord Oliver's remarks in Alcock at page 408. So if your actions lead me to believe that I have been the cause of somebody else's death, and I suffer, say, post-traumatic stress disorder, in believing that, then I am able to recover against you for that psychiatric harm. Now, the sixth and final principle, of course, is that every other type of potential claimant not included in the types mentioned before, then all such claimants who suffer psychiatric injury as a result of witnessing death or injury of someone else, or perceive the risk of death or injury to someone else, will be subject to what is termed the control mechanisms for secondary victims. Now, these control mechanisms can be stated in 5 points. The first being stated by Lord Lloyd in Page and Smith, and the remaining 4 by Lord Ackner in Alcock. And these control mechanisms are as follows. The first, according to Lord Lloyd, is that it must be reasonably foreseeable that a person of normal fortitude or ordinary phlegm might suffer psychiatric injury by shock. So reasonable foreseeability is necessary, and it means that bystanders are therefore excluded as the law considers them to be of a certain fortitude. Lord Ackner provides us with the 2nd to 5th requirements. So too, there must be a close relationship of love and affection between the person who has been killed or injured and the claimant. So of course, close relationship and love and affection between the primary and the secondary victim. The third is that the claimant must be in close proximity in time and space to the accident or its immediate aftermath. So there needs to be what is called temporal and spatial proximity. The fourth is that the psychiatric injury must result from a sudden shock. So there needs to be what is termed an assault on the senses. So it can't gradually come over time. And lastly, the psychiatric injury must be caused by seeing or hearing the accident or its immediate aftermath rather than being told about it. So it needs to be experienced with your own senses. Now, this primary-secondary victim distinction is crucial in any analysis of nervous shock, as it is the secondary victim who has to satisfy the control mechanisms. Now, according to Lord Lloyd in Page and Smith, a primary victim is usually someone within the zone of a foreseeable physical harm in the event the defendant failed to take reasonable care. So it means that someone either physically imperiled by the defendant's negligence and suffers nervous shock, or someone who, although not physically imperiled by the defendant's negligence, suffers shock as a result of a reasonable fear for their own safety, will be able to recover. So for example, I have seen a past tort exam question which gave a scenario of a train crash, and it referred to 2 persons, A and B. And what it did was to say that A and B were working on a train line when a train was negligently directed down the track where they were working. Now it stated that A and B were facing away from the train. The question then said A looked around when he heard the train, and he basically saw his life flash before his eyes. The question then also went on to say B was deaf and was facing away from the train. And at the end, the exam question said that both suffered from post-traumatic stress disorder as a result of their experience. Now, the classic approach to such a question, of course, would be first, deal briefly with the recognized psychiatric injury. But then you go on to discuss that both A and B are primary victims given the scope of Page. Please do not let the examiner throw you by throwing in a red herring saying that B is deaf. That is completely irrelevant, because the fact is he was within the zone of danger and then he suffered a recognized psychiatric injury from the incident. Now, this final case that we will focus on is the case of Roth, which is a plural plaque litigation case, And in Rothwell, in 2007, we had several claimants bringing an action in which the courts had to consider several test cases. The point was that one of the claimants in Rothwell brought an action to the extent that he had suffered a recognized psychiatric illness based on the fact that he was of the view that he would develop an illness in the future. Now, the courts considered that that was a little bit of a stretch, and as such, they denied his claim. It is an interesting case to look at, though, because it was a point in time when the courts had to consider this whole principle of psychiatric harm in a recent case. That covers this segment on psychiatric harm, and we will now pause briefly before we conclude with pure economic loss.